everyone. So I think it's 1:30. We'll go ahead and get started. So my name is Elizabeth Bolduc. I am a labor and employment attorney here at Buckley & Conkle. And so today we're going to kind of talk through the EEOC, and we're going to include the OCRC in this discussion just because we are in the state of Ohio. So that is the state administrative agency where the EEOC is the federal. So we're going to talk about both. So today, when you walk away from this presentation, I think you should understand who these players are, what they do, kind of the process, and then you're going to take away some tips and tricks. So if you get a charge of discrimination, you're going to know how to handle it and kind of be, above the game. All right, so let's get started. So I've been mentioning the EEOC, which is the Equal Employment Opportunity Commission. And the basics about them is they were federally created when Title VII was enacted by Congress in 1964. So they've been around for a really long time, and they've been tasked with a few things. So they've been tasked with not only enforcing federal employment laws that make it illegal to discriminate against people, but they come out with different things such as what they think that a law should be enforced and how it should be enforced. They come out with enforcement guidelines. They do trainings. They raise awareness. And in the last couple of years, they've been really active in DC, especially with the Me Too movement. They've created workforces that really combat workplace discrimination and harassment. So some of the laws that they enforce is age discrimination, disability discrimination, equal pay. So that actually falls under their territory and not the Department of Labor, wage and hour, many people think, genetic information, traditional harassment, national orientation, pregnancy, race, color, religion, retaliation, sexual harassment, and then sex as well. So this is a 5-person commission. Right now it's a little unique in the sense that the commission only has 2 acting commissioners. So the third one, who was recently up for renomination, was not put back on the commission, and someone who President Trump elected or appointed actually withdrew that appointment because he said it was too political of a process. So right now there's actually only 2 acting members, which means their hands are pretty tied. So they're probably not going to be very active in the sense of releasing new enforcement guidelines and things like that until they get some more people to help them out. But it is a bipartisan commission, one Democrat and one Republican, but I'm sure it will change when they get some new commissioners on there. All right, so like I said, there is, a board typically of 5 commissioners, but they have district offices throughout all of the United States. They actually have 15 district offices. So here in Ohio, we deal mostly with the Indianapolis and the Philadelphia district office. As you can see, people who fall over on the Cleveland side of things and the east side of the state really belong to the Philadelphia district office, and then people who are in central and north and south Ohio fall under the Indianapolis. But this just kind of gives everyone an idea of kind of the layout of the district offices. All right, so like I said, I mentioned in the very beginning, there is a state administrative agency that does essentially the exact same thing as what the EEOC on a federal level does, and that's the Ohio Civil Rights Commission. So very similar to the EEOC, that has 5 commissioners, but instead of being appointed by the president, they're appointed by the governor. And similarly, they are, responsible for education and enforcement of here Ohio's anti-discrimination laws, so not the federal laws, but the state laws. And, again, they were created, this commission was created by the Ohio Civil Rights Act in 59. The agency later changed its name to the OCRC in 1961. And there, they have more discretion in more areas. They also deal with housing and public accommodation, so it's not just employment there and higher education. As you can see on the little map, it's a little bit little, but there is a couple different, local or regional offices, as they call them. There is two in Columbus. They have the Central, but then they also have the Columbus. There's one in Akron, Cleveland, Toledo, Dayton, and Cincinnati. So when people file, those are typically the offices that they file in, and those are where the investigators sit. All right. Okay, so I think it's really important to realize the statistics of the EEOC. So this is the EEOC, not the OCRC, but it is, these stats are inclusive of those that are dual filed with both administrative agencies. As you can see, might be a little bit small, but retaliation as a whole under all statutes are always the most filed charges, and that's good for any state, not just Ohio, but Ohio follows pretty closely with that. Then the next you will see is just disability discrimination. So I think that's a surprise to most people, especially in this Me Too movement. I think people think, oh, well, sex is definitely the most filed. And while I think they're right onto something that, more people are willing to file sex discrimination and harassment charges, it's still not there yet in the sense of, what really people are filing for. So as you can see, disability discrimination is number one, then retaliation, and then it looks like race, and then a close second is sex, and then some outliers that are kind of lower. But this just gives you a good idea of when you're doing your trainings and when you create your policies of really what is coming out of the state of Ohio and where you should focus your time. Although everything is important, you can kind of touch things a little bit more when they're in it too. All right. So this is just a map of everything in the United States and where and how much charges have come out. So as you can see, Ohio's kind of in the middle. They have just a little bit over 2,000 charges filed in 2017. So, there looks like there's some states that are, really low. So like Maine, and there's some states that are really large, like Texas, but you have to remember the population. So, Ohio is on the higher end considering its population of how many charges are actually filed each year. So I think this is just a great statistic just so you're aware of it. All right, so when you are getting a charge of discrimination, some key things to remember, and I'm just going to put this as a context, is the EEOC comes out with a 5-year or 4-year strategic enforcement plan. So these are things that the EEOC has come out and say, these are really things that are really important to us. When we see charges of this or allegations of this, we're going to pay more attention. So whenever you get a charge of discrimination that falls into any of these categories, you're going to really want to pay attention to that charge and almost baby it, because those are the ones that are going to come in a lot of scrutiny. So just for everyone's knowledge, the first one is eliminating barriers in recruitment and hiring. So this comes in when there is like a hiring practice that is on its face discriminatory. So that could be, you have a policy that says you have to lift 100 pounds. Well, a lot of women, definitely me, cannot lift 100 pounds. And so that on its face, eliminates a lot of women from applying from that job or being selected for that position. So those are the type of things the EEOC is really caring about. The second is protecting vulnerable workers. So this is like migrant workers, immigrant workers, and, underserved communities. So when people, do file national origin or race, they're really looking at that and protecting certain populations. Next, these are developing issues. So although there is some back and forth kind of right now what's going on, with what's happening with the sexual orientation and transgender issues. Those are things the EEOC are really passionate about. So one of the commissioners who was on the commission last year but not reappointed, she was very passionate about LGBTQ issues, and she has come out to say that we will enforce those under Title VII, where some federal courts are saying that, you know, that's not necessarily what they think. So there's a little bit of a split there. Hopefully the Supreme Court will, you know, kind of give us some light on that issue coming soon. And if you're interested in that, look on our webpage because we have a lot of documents and web posts addressing that. But that is something that they really do care about. The next is ensuring equal pay for workers. So that's just, you know, you're paying one group of people less than another group of people. And then people who don't have access to the legal system. So people who are, you know, less likely to file complaints and charges, less likely to be able to. So people who don't have transportation and things of that sort. And then, you know, harassment as a whole. So what is the culture of your workplace? Do you have harassment engraved in your culture? Is it acceptable there? When there's cases like that, I know there's some organizations that have been in the news lately for their type of culture. And when you have a workplace like that, they're definitely paying attention. All right. So now we're going to get to the fun stuff, which is the overview of the process, the EEOC process. So first, there's going to be a charge filed. And after we go through this, I am going to show everyone a sample of what a charge looks like. So just stay tuned for that. But this is something that I think a lot of people have a, you know, unknown or a misinformed perspective of. A lot of people think that there has to be one person filing a charge to initiate it, where in fact the commission itself can file a charge. So like the last priority we were talking about, when there's a workplace culture or a hiring practice that is just on its face discriminatory or really offensive, the EEOC itself can file, one of the commissioners can file a charge. So it doesn't have to just be one of your employees. The EEOC can come in, and I think that for, you know, one of the instances that we've seen in our office is when there's a settlement agreement or a severance agreement, and in those severance agreements, they say something illegal, such as that it waives an employee's right to file a charge with the EEOC. This is one thing that the EEOC hates and will automatically file a charge if they catch wind of it, and then you open yourself to an investigation. So next we're going to talk about one way to handle a charge, which is mediation. So mediation, we'll get into the specifics a little bit later, but there's a couple of things that can happen with mediation. First, at the mediation, an agreement is reached and it results in the charge being closed. But if the mediation is unsuccessful, then you go through the investigation as you would if you didn't even go to mediation. So it doesn't harm you, but it certainly can help you. If you choose not to mediate, you can go forward with an investigation. So there's a couple ways an investigation can go forward. There's a, you know, first they could find that the evidence did not show the violation of the law. So they're going to do a bunch of things. We're going to get into what an investigation actually looks like, but they can come out with saying that there was no violation of the law, and then they're going to issue a right to sue letter. And that allows the charging party to file a lawsuit on their, if they want to, and the charge is closed. So they can also request the right to sue letter and just say, we're going to forego our EEOC, you know, investigation, just give us the letter, and then they'll sue in court. Sometimes a settlement is reached between parties outside of mediation. So an investigation is going, and then, you know, you work with the party and the party's attorney, and you reach a settlement agreement. And as one of the terms, you tell the EEOC that you're going to, you know, they're going to withdraw their charge, and the EEOC blesses that, and then you have a settlement. If there is a violation of the law after a thorough investigation, the EEOC has to try to attempt to resolve it before filing suit. And so if that is true, you'll reach an agreement and the charge is closed. If the conciliation fails, the EEOC has a choice to either issue a right to sue letter and allow the charging party to sue on their own, or if it's something that the EEOC is really passionate about, the EEOC will file a lawsuit on your charge. And then there's one last thing. We're going to include it because it is, a factor, but don't get too excited. This doesn't happen too often. The charge is dismissed with no further investigation. This is something that when the charge comes in, it's just so on its face, not protected or can't happen. So it could say that they fired me because my hair is purple. Well, that's not a protected class, and that's not something that the EEOC enforces. So they just kind of, say that there's no action required, and they close the charge. So that's a big overview. We're going to actually now talk about what you do when a charge is filed, and then we'll go through the investigation and all these things that we just talked about. All right. So when the charge is filed, that does not necessarily mean that there is a finding that your organization engaged in any sort of discrimination. It's simply to put you as an organization on notice that the charging party is alleging you did something wrong. So when the charging party goes in and files a charge, your organization will be given notice. Well, they're supposed to within 10 days. That doesn't happen all the time, but that is what they're supposed to do. When you do get a charge, they're typically going to give you a portal information. We suggest go into that portal information, download the charge, and, see what the action is, understand the action. Sometimes the EEOC will say no action is required at this time. Sometimes they will have different asks, so just be cognitive of that and, respond accordingly. So a lot of times the charge will say respond within 2 weeks. Well, I don't know about you, but I don't plan for charges of discrimination to come up. So when necessary, always request an extension. This is one thing we're going to get into, but you're always going to be punctual and timely with the EEOC. You're never going to want to blow deadlines. So if you think you need more time, and I would suggest you will always need more time because you're gathering documents, you're going to be talking to people, ask for more time. I ask for 30 days or whatever your company thinks is reasonable. Explain why that's reasonable. Explain why you need that time. Lay it out for them. And they're typically going to grant that extension. I've actually never been denied an extension when we've asked, but we always address why. Okay, and then lastly, take note of who the investigator is. So it's always going to say your investigation is assigned to this investigator. Sometimes they'll have the secretary at the beginning because it hasn't been assigned to someone yet, but as it proceeds in the investigation, take note who the investigator is. Are they really hostile? Do they not want to talk to you? Do they want to work collaboratively with you? Do they want to be informed of every little thing? Do they want to be given status updates? And I think that's one benefit of using a law firm is that, a lot of attorneys do have ongoing relationships with these investigators, so they kind of can say, oh yeah, we have investigator X and he or she likes this, this, and this. So we can, go through the investigation how they like, not how the organization likes. So next, we just have samples. So this is just a sample of the charge. This will come in first. This is the thing I was talking about that would come in within 10 days of a charge being filed. And it simply just gives you notice that there's been a violation or alleged violation, and it gives you access to the portal, your password, and the charge number. So go in there and, download it, print it, let everyone aware of it, and start gathering what you need to gather to respond. And then this is actually what a charge looks like. So they're going to have the charging party's name. They're going to have a charge number for you. They're going to have, their address, your address, and then they're going to click or fill in the reasons why they think they were discriminated against. So was it their color? Was it their sex? Was it their national origin? Was it retaliation? Typically, they're click, check more than one box. So it was national origin, it was also my sex, and it was also retaliation. And they're going to provide a description of why, and then it is going to give you a date to respond. It's going to tell you what to do. So no action is required at this time. If you would like to mediate this, you need to mediate this by this date. So it's basically a first instruction of what the investigation is going to look like. All right. So once you get a notice of a charge, you're on notice that you should start investigating the allegations and you have something to do. So if the EEOC says, we want a response, we want a position statement that lays out your side of the story by this date, well, you have some homework, and so you have to get started. And the first thing to do is to understand the allegations. What are they saying? Why are they saying those? Who is involved? All of those things. Is this a violation of the law? Is this not a violation of the law? Sometimes they're going to say really lavish things, and you might know that they're on its face wrong, but the EEOC doesn't know that, so you have to go ahead and gather all of the documents to support your position. So, typically that includes the personnel file. Is there performance evaluations? Was the person terminated because they don't show up to work? Is there attendance records that can support that? Is there medical slips or the lack of medical slips to say that they didn't request an accommodation or they did not have a disability? Is there pay information that shows that they are making the same wage as, their similarly situated coworker? Have they acknowledged your handbook? Have they gone to trainings? Have they signed into those trainings? Are there witness statements out there? All those type of things that are in a personnel file or that might be out there to support your position. So you want to go ahead and get those documents. And I know a lot of you are probably thinking, well, this sounds like it's going to take us a lot of time. And you're right, it probably will take a great amount of time, but you're going to do all of the legwork at the front. So if this investigation concludes that there was discrimination, it's going to likely end in a lawsuit if you can't get the thing settled. And then you go through a process called discovery, where all these documents are going to be needed anyways. So if you go ahead and just invest the time now, you're going to have a better response. And then if things don't get settled, you're going to be prepared for when it gets in the court. And then you're going to want to start talking to the individuals who are either, named in the charge or have knowledge. So is that charging party supervisor? Is it human resources? The people named in the charge, and then the coworkers who are similarly situated. So maybe they're saying that I was called these racial slurs on this line on this date. Well, look at the records of who was working on that line or near that line on those dates who might be able to confirm or deny those allegations. And then, from there you would get witness statements. So after you start conducting your investigation, that's when you should start taking steps of what are we going to do from here? How are we going to respond? So roundtable with HR, legal, and upper management and say, here are the facts we have. Here are the laws. What are our risks? What are our potential liabilities? What are our strengths? What are our bad facts? Do we need this to go away, or are we comfortable with proceeding in an investigation because we know nothing bad is going to happen, nothing bad is going to come out? And based on that conversation, you're going to know which way you're going to want to direct your response. Are you going to want to go to mediation? Are you going to try to get this settled? Are you going to say, we have no interest in settlement or mediation because we know that although it's a long process, an investigation is better for us because nothing bad's going to happen or come out, and we are going to have a no probable cause finding. So after an action plan is determined, typically, you will write a response of some sort. So what does a position statement look like? And this is really your chance to tell your side of the story. So what will happen is charging party will come in in that charge that we discussed earlier, say this is what happened to me and this is why it was illegal and this is why you need to do something about it, the EEOC. And then you have a chance as an employer to say, no, that didn't happen. Here's our side of the story. And then after and based on this position statement, the EEOC is going to go back to the charging party and say, okay, this is what they're saying. Do you have anything to rebut that or say, is that pretext or is there something wrong with that? And that's kind of how their investigation goes. So you're going to be really cautious of what you put in a position statement. Do you want that to get back to the charging party? You know, you're never going to say negative things about the charging party in a sense of, you know, making slander remarks, but you couldn't say their performance was bad because if that was true, then, you know, that person already knows it and that's the reason. So here's some tips and tricks about what a position statement really should include and how you should write one. So first and foremost, you're going to want to be clear, concise, thorough, and responsive. So be clear, lay out the facts. These investigators just want to know the facts. They don't want to know a bunch of, you know, distractors, and they're not going to want to get confused. So don't steer away from the issues. And be thorough and responsive. Answer every single allegation. So, you know, if they say I was discriminated because of race, and you say, well, this person was terminated because they did not show up to work every day, answer that. But then if they later say, oh, and also on July 2nd, I was sexually harassed, don't think that your due diligence was done because you said, well, we terminated her for a right reason. You still have to address that allegation. So I think that's one of the biggest mistakes when it comes to position statement, that they're not thorough and they don't actually respond to every single allegation. So what does a well-drafted position statement look like? Well, you know, it's going to take the charge seriously. So I know how frustrating it can be if you get a frivolous charge and you're thinking, oh, this is going to take so much time. But if you have that tone in your position statement, you're going to offend the EEOC investigator, and they're going to take this charge a lot more serious, and they're going to be a lot harder on you. So take it serious. They take their job serious, and it's being respectful to them. First impressions matter. So make sure your grammar is good. Make sure your tone is good. Are you being argumentative in your position statement? That's never what you want to do. You just want to say the facts. You don't have to win at trial. This isn't an opening statement. This isn't a closing statement. You don't need to, you know, point to case law. I mean, there's sometimes that case law might be appropriate if it's a very nuanced, but, you know, the run-of-the-mill employment, you know, race or sexual orientation or what might be, it really should avoid legal arguments at this point. Don't just say this is our side of the story and don't provide evidence to support it. If you say, well, she was terminated because of her attendance, provide her attendance log, even if they didn't ask for it. Something is way more believable if you provide, you know, documentation than just saying it on its face. Let's see. You know, be punctual. If you blow a deadline, that's going to look really bad. That's going to go back to they don't think you're serious about this, that you don't care about discrimination, and that's going to make the investigation really hard on you. And it should be noted that a well-drafted position statement can really accelerate the investigation, because if you have a clear response that rebuts that discrimination happened, they're going to close the case a lot faster than if you have a muddy one that they're like, well, maybe, I'm not really sure what they're saying here. It could be, it's just confusing to them. They're not going to give you any benefit of the doubt. In fact, they're going to give the charging party the benefit of the doubt. So you have, you know, to be thorough. So what does the position statement itself actually look like? So like we said earlier, make it easy to read. Don't make the investigator have to do a lot of work to try to follow what you're saying. You know, start with the introduction. Our organization received the charge of discrimination on this date. Our understanding of the charge is that Susie claims she was terminated because of her sex. And then you say the short reason: she was not terminated because of her sex, but rather she was terminated because her performance issues. And then you're going to go into background information. They don't know you from Adam. What does your company do? Do you make widgets? Are you in the temporary staffing business? Are you a family-owned organization? How many employees do you have? Do you have multiple sites? I mean, what do you think is important to know? So if you have a really specific and, business culture, you're going to want to say that in there. Say, we work at home most of the time, or you can say, this is unique to our business, that it's not unique to most businesses, because those are things that they're not going to understand. They've never been into your work site. They don't know what it looks like. They don't know how your culture is. But if you can lay out all those things, they can, sympathize with you and get on your team. So then you're going to go with charging party's employment history, and you're going to say, charging party was hired on this date. This was her job duties. She worked in this department. This was her hours. And then you're going to, if this is the case, you're going to go into attendance issues or performance issues. She had a bad attitude. She failed to attend trainings. She violated this code of conduct. And you're going to lay out when there was receipt of that code of conduct or that training, and when they violated it. Did you talk her through the process? Do you have those, step 1, step 2, step 3? Did she exhaust all of those? Those are the times you're going to clarify all that. And then if it was a sexual harassment or something like that, you're going to lay out your investigation. So on X date, charging party came to us and alleged she was discriminated against because of her sex or sexually harassed. We talked to these people. We concluded this. We concluded that there was sexual harassment. And the minute we concluded there was, we took the right actions. We terminated X, Y, Z, and we made sure that there was no retaliation happening. What was your stance? It's okay to say that sometimes that sexual harassment happened in the workplace, as long as your response was, accurate and there was no retaliation. You're going to want to lay that out, because that actually is a strength. And then you're going to talk about when was the decision to terminate that employee or that employment action, so that discipline or that demotion happened. Why was that decision made? And then you're going to conclude, and in your conclusion, you're going to say, once again, summarize, this is our stance, and you're always going to indicate that your willingness to work collaboratively with the EEOC. So let us know if you need more documents. Let us know if we can do anything else. And you don't want to be too aggressive here, but let them know that you do think that you have a good stance, and you were willing to help them, if they need more information, but you're not just going to give everything to them. All right. All right. So after a position statement is submitted and they go back to charging party, they could ask for more documents. So if you give documents uphand and then upfront, they're likely not to ask for documents unless there's something specific that you forgot to include, or that charging party says, well, there's a document that says, let's get rid of her because she did this or that or that. So that's really when they're going to come back for documents, as if you don't include them or they think there might be more out there. So they have the right to request specific documents, and they typically tend to be pretty broad. So if they are overbroad, you're never going to want to just ignore them. That shows really bad faith, but rather you're going to want to work with them and say, well, can we narrow it down? There's, you're asking for all of the similarly situated employees, but we're in a factory and everyone technically, we have 500 employees that are her, similarly situated employees or coworkers. Can we narrow it down to her line or the people who were hired in that year, or, work with them? They typically will understand if their request is overly broad and too burdensome for you. And then at that point, you can kind of come out and hash it out and come out with a game plan of really what do they want. Don't simply ignore the request. I think I just said that, but that can get you in a lot of trouble. So the EEOC actually does have subpoena power, and there's case law from the Supreme Court, within the last few years that gives them a lot of authority and a lot of discretion to ask for virtually any material that might cast light on the allegations against the employer. So that's pretty much anything. So if you don't do that, you can be in hot water, not only with the EEOC, but with that subpoena power. And then If you, in fact, do think that there's something that is against, that you object really hard to the subpoena, you contact your lawyer. You have 5 business days from the day of being served with a subpoena. So that's not a lot of time to figure out, what the grounds to objecting it are and getting that served back to the general counsel for the EEOC. And it's pretty clear failure to object within the 5 days waives your right. And there's a lot of things that have to happen in that objection. You must separately identify each portion of the subpoena and why you intend not to comply. And then based on that, the EEOC will make a decision within 8 calendar days or as soon as possible. So that's request of documents. Sometimes the EEOC will conduct interviews. They could happen by the phone or on person. They might come to the work site and conduct interviews. But you're going to want to prep all of your employees for an interview, and you want to be aware of what they're going to say. What information do they have? I mean, that should have all been obtained in your investigation from the very beginning, but you never want to know, maybe an employee won't tell you everything, but for the most part, you're going to want to be aware of what's out there. And then, something to consider is having an attorney present for interviews. When you are talking to your employees and you have an attorney present, you have some attorney-client privilege, but also during interviews of upper management, attorneys are allowed to be present and they can make objections in the interview. And so sometimes that might be really beneficial for your workplace. But when you talk to all the employees about their interview, you're going to want to say, be truthful. You never want to tell them to lie or hide the facts. It's very similar to a deposition if anyone has ever been prepared for a deposition. The EEOC might say, what did your lawyer say? Or what did your supervisor say? And so if you're telling people not to be truthful, that will likely come out, and then you've blown up your whole investigation. So tell them to answer the question asked. Don't assume what the investigator is saying, but really listen to them and only answer the question asked. If you don't know, don't guess, don't predict, don't assume. And if you get some pushback, it's okay. It's okay if you don't know what's going on. There's no rule to say that you have to know everything. And I think a lot of times employees get caught up in the fact that they don't want to feel bad for not knowing a question. And in our eyes, if they truly don't know the question or they truly don't remember, that's a perfectly okay answer. And don't overcoach testimony. So while you want to make your employees comfortable and calm during this process, you don't want to seem too rehearsed because then it's going to seem very disingenuous. Maybe go through the policies and procedures with your employees beforehand so they're aware or they remember your policies or your anti-discrimination and harassment policy. So if the EEOC actually comes on site, so sometimes they'll do, interviews on site, like I said earlier, but sometimes they'll just want to come see the workplace. What did that line look like that the charging party worked on? What was that culture? What was it looking like? How many people are around? How many people could have seen it? So those are things that could happen. If this happens, so if the EEOC comes to your work site, you kind of are put on notice that this isn't just your run-of-the-mill investigation, and you really should be paying attention to it because they're paying attention to it. So it definitely indicates a heightened interest in the charge. I would plan for having this last about a day. Certainly it can be less than that and it can be longer than that, but typically they'll be out there for one full day. And you're going to want to work with the investigator. So if they say, we're coming out on February 2nd, but you have a production deadline on that day and everyone is going to be extremely busy and you can't handle from your business needs one person being out every few minutes, work with them and say, this is the reason why we need you to come on this date. And say, what are you wanting to see on those dates? We will prepare them beforehand. Who do you want to talk to so we can have the schedules that those people can be off the line or be out of their job for a period of time. And then, beforehand, make sure you review the charge. Remember what the charge says. Remember what your response says. What were the supporting documents that you provided in the first hand? What are your employment practices? You're going to want to know all those things before the EEOC comes out. And then have an action plan for when they come on site. Where are you going to put them? You don't want to just have them laying around or standing around in your warehouse. Have them, put them in a conference room that is somewhere discreet, that they're not, making a scene or getting in the way of your business needs. And then afterwards, provide a summary of what happened. What did they learn? Who did they talk to? What are the documents did they see? And what do you want them to take away from that on-site investigation? All right, so that's what the investigative process looks like. And I think earlier we talked about it, but there's some alternative outcomes that I want to talk about before we talk about probable cause findings that can happen. So a charge is withdrawn from the charging party. The charge can be settled, like a voluntary settlement. That happens anytime during the course of the investigation. Some pros to that is that the settling a charge early might save you some time and effort, and it's informal. There's no admission of liability. So sometimes once you know that the investigation is not going in your favor, maybe it's, rings about let's get this settled, and we can put terms in our settlement agreement that are mutual beneficial for both parties. Some things that can happen other than that, though, is the charging party can request a notice of right to sue. So most states have a charging party or a plaintiff has to exhaust their administrative remedies before they can file a lawsuit. So Ohio is a little unique in the sense that they don't have that, but a lot of people still file an EEOC charge because it's free discovery. And so even if they're not represented, or even if they are represented by a lawyer, a lot of times plaintiff attorneys will say, go ahead and file the charge because it's going to get a lot of the information that we're going to want to know if we file suit. And so go ahead and do that. But the EEOC typically takes about a year to investigate a whole charge. And that can be a long time if someone is really slap happy to sue. So if 180 days go by, a charging party can request the right to sue letter that gets them their foot in court. If it's less than 180 days, sometimes the EEOC will give you the right to sue letter if it is unable to finish the investigation within 180 days. In my experience, the EEOC is not too stringent with giving out the right to sue letter. They have a lot of files on their desk. So the more cases that they can close, the more charges that they can close, the happier they are. So those are just some alternative outcomes. One other outcome of an investigation could be no probable cause finding. So that means that there was obviously no discrimination on the work site and that you did a good job in your investigation. The EEOC concludes all the information that they have obtained. So that's the documents, that's the that's your position statement, that's the interviews, does not establish a violation of the law. At that time, they're going to dismiss the charge and issue that notice of right letter. From that letter, charging party has 90 days from receipt to file a lawsuit. So that is something to pay attention to. If you get a dismissal and a letter, you're going to want to calendar it for 90 days that they have once that 90 days are up, they no longer have that right to sue. And that's for everything under Title VII. The equal pay violations do have a longer statute of limitation than that. And so since we mentioned the OCRC in the beginning, if a charge is filed with dual filed, meaning that the OCRC conducts the charge first with the support of the EEOC, if the charging party doesn't like the outcome of that state finding, they have 15 days to file for a review from the EEOC. So what would happen is they file a charge with the OCRC, they get a no probable cause finding, they don't like that finding or they think there's something wrong with the investigation, they have 15 days to notify the EEOC and say, we want the EEOC to start an investigation or look through that investigation. And then there is judicial review in Ohio from the OCRC, and that has to be filed within 30 days. So it's really important to be aware of these things because they really could preclude a lawsuit if the charging party doesn't file within a certain amount of time. So the next one is if the investigation comes out with a reasonable cause finding. So this means that based on the investigation, the EEOC has made a determination that discrimination occurred in the workplace. So by statute, the EEOC is required to attempt to resolve findings of discrimination through informal methods of conference. So I think a lot of times people think, oh, well, you're gonna, if you get a reasonable cause, that's the end of the world. It really isn't. So, you do go through a process similar to mediation to try to settle that charge. And the conciliation process is completely voluntary. You do not have to be involved in it. The EEOC has to attempt to resolve it, but you as an organization do not have to participate. So some positives about conciliation is obviously the EEOC thinks that there's been a violation, so maybe a court would too, or a jury would. So those are things to keep in mind. But conciliation discussions are always negotiable. So they don't have to be reasonable. When the statutory language says that they have to attempt to resolve it, it doesn't have to attempt it. I don't want to use the word in good faith because there's some case law out there to say it does have to be in good faith, but they can have a big number. And certainly don't be emotional when you see that big number, because if you know how to negotiate, you're not going to take the first number unless that's something you're comfortable with, but you can certainly have a counter. Say, how did you get at this number? EEOC, what is your reasoning for getting at this number? And say, we don't think your number is right because of these reasons. We're now offering this. And so you have an opportunity to try to resolve. This is kind of the last opportunity to kind of resolve the charge informally before a decision on whether the EEOC will litigate it or not. A positive about this is it removes uncertainty in the cost of litigation, and it is, for the most part, rather inexpensive if you're taking into consideration how much litigation costs and the result of being in the public eye, and all of those nasty things that litigation brings out. All right, so if conciliation fails, meaning that the parties don't reach an agreement, the EEOC must then decide whether or not it is going to sue. And so the EEOC considers several factors. Obviously, the seriousness of the violation. What type of violation is it? Is it something that's on their strategic enforcement plan? Does this have a wider impact? So could this, affect multiple people? Is this likely to affect multiple people? How important is this issue on the agency's, mind to combat workplace discrimination? And what are the resources available to the agency at that time to litigate the case effectively? So if they know it's a really slam dunk case, they're likely to take it because it's not going to be, he said, she said, he said, she said, we have to get some experts in, and it's going to be messy litigation. If they have a good case, they're definitely going to take it because it's going to be a lot easier for them to litigate it than a case that's kind of in the gray area. So that is, what happens if there is an investigation and the types of results you can get in an investigation, and then, whether it gets to litigation or not. And then there is a mediation, which we talked about first when we went through that, kind of flow chart. So mediation, I think, is a really great option for a couple of reasons. So if you have a charge that maybe you are likely not to win, or you are aware there might have been some discrimination, or there might have been some sexual harassment, these are the type of charges you're going to want to try to mediate right away. And even if you know there isn't any merit to the charge, it might be more effective so you don't have the human resource or the upper management time to put together all these documents and go through the investigation and work with your attorneys to provide a statement and an investigation to the EEOC. Maybe it's just cheaper for you and to go through mediation and reach a settlement with the charging party. Maybe the charging party still works in your organization and you really want to address what happened and make sure it doesn't happen and work together to change the culture of your organization. So there's a lot of reasons why the mediation program is very beneficial. So first, it's informal. You have a neutral mediator who facilitates conversation, and everything is confidential in a mediation. Settlements are binding in a mediation, so it's not like you're going to reach an agreement there and later on the road that it's not binding and they can again file a charge of discrimination. So it identifies bad employment practices and repairs broken relationships. So settlement agreements secured during mediations are not necessarily a admission of guilt by the employer. And typically settlements have that in there. So a lot of times I think people say, well, we don't even want to, mediate this because we don't want to admit or look like we're admitting that we did something wrong. In a mediation, you're never going to change each other's minds. I mean, that's not really the whole idea of mediation. It's really to reach an agreement and go your separate ways, or if they're still there, repair those ways and be able to work together. So at a mediation, some of your best practices are, the person who shows up to the mediation, take it seriously. So make sure you know that you're not wasting anyone's time. The first thing that they're going to do to upset someone is to sit there at a table and not talk or not be willing to put something on the table. So even if it's not a big number, be willing to put something on the table and send a representative who actually has authority to resolve the dispute. So don't send someone who has to call every 4 minutes to see if they can do something. Of course, it's okay to let them call if they've hit their threshold and to see if they can have more authority. But don't send someone that simply has no authority to act. Be prepared. So beforehand, know what your facts are, know what the good facts are, know what the bad facts are, know what they're saying. Anticipate what charging party is going to say and why that charging party feels a certain way, and prepare to respond or work through that problem. Set your goals beforehand. So we want to settle this with $2,000. We want to settle this with these goals in mind. And when you know that going into a mediation, you're more likely to reach your goals than if you go in unprepared and just not knowing what you want. The goal of mediation is not, I think I said this earlier, to find facts. You're never going to convince a person that you didn't discriminate, because if they're filing a charge, they're never going to get on your camp, but you're really just going to leave the table with an agreement in hand. And the nice thing about mediation is it doesn't have to be monetary. So I've been involved in a lot of mediations when really the charging party just wanted a different culture. So whether they are still working there or not, they wanted them to conduct training and sensitivity training and fix the cultures and fix the policies. They did not care about money whatsoever. So I think that's a common misperception that it's all about money. It's really not. Do you want a settlement that says, okay, after this, the person is going to resign from employment and we're going to go our separate ways? And you're never going to walk away from the table without reaching a settlement if a settlement can be reached. So don't say, well, let's sleep on this and then talk about it tomorrow, because likely that person is going to then talk themselves up, say, oh no, I don't want to do that. I don't want to do that. They're going to talk to other people. They're going to get influenced. So if a settlement is to be reached, reach it on the same day that you're there. And, similarly, if a settlement is reached, put it in writing. People change their minds really quickly. So if you don't have writing that day, it's likely to fall apart at the next day or the next couple of days. So that means, kind of being prepared. Come prepared with some type of settlement agreement in mind. Be willing to change the terms and such, but but have an idea of what types of terms and conditions you want. All right, so those are just some tips for that. And so that's the whole investigation process in the EEOC OCRC process. There's mediation, there's an investigation, and what happens if an investigation finds a probable cause or does not find probable cause. So no matter what, after an EEOC investigation or a charge, you're going to go ahead and review your anti-retaliation policies with individuals, I mean, everyone ideally, but specifically with individuals that participated in the investigation, and even charging party, if charging party is still there and working on your work site. You want to identify employment practices that probably need refresher trainings. So does your anti-harassment and non-discrimination policy say X, Y, and Z, but people had no idea that it even existed and that you prohibited discrimination? Do you need to conduct a training for the whole plant, for a certain department, for a certain, area? And maybe there's something that's worded in employment practice that has people confused. So they have to report to one person, but that person's no longer there. Does that need to be updated? There's definitely there is some positives of an investigation because it really does help refine your culture, and it can, give you an idea of what your employees are thinking and how to fix it to be a better workplace. But certainly you definitely want to review your anti-retaliation policies. If you will remember to the statistics of before, retaliation is the #1 charge. And that's because sometimes an investigation will happen and then the person will be terminated right after, and then that's a slam dunk case for the EEOC. All right, so that brings us to the end of our presentation. So I think we actually did pretty good on time. I am a fast talker, so thank you all for staying with me. Do we have any questions? One question.
How long does it generally take to hear back on a charge?
Yeah, so that's the hard thing with the EEOC. I would say it takes anywhere between a year is what they typically say. And my policy is no news is good news. So if you don't hear anything back, that means it's okay. So you really should be more concerned if you're hearing things. Sometimes if you have a certain investigator, they're more prompt. So they like to get files off their desk really quickly, and they'll investigate things within 3 months. But then you could have another investigator whose just caseload is very insane, and they see the charge and they know it's not really a priority, and that could take them well over a year. So it can really depend, but my rule of thumb is if you don't hear anything, that's okay.
Another question, can you discuss confidentiality of documents filed with the OCRC?
Yeah, so that's actually a great thing, and I think I forgot to say that. There are some documents that you are going to want to mark confidential, so that's Social Security or trade secrets, anything that's really specific to your business. So there's a couple ways to do that. You can mark a position statement and documents confidential in the respondent portal if it's the EEOC. If it's the OCRC, talk with the investigator, have your attorney talk with the investigator to let them know that it is confidential. So typically I will write in there when there is confidential information that this position statement is confidential and the company does not consent to use other than this case, and then I will mark it as confidential as well. But there's just ways to specify that it's confidential. So that's a great question. Thank you so much for asking that. Any more questions? No? All right. Well, if anyone thinks of any, like I said, email me. I'm happy to talk about this. This is something that I'm really passionate about. If you couldn't get that from my fast talking. But everyone have a good day. Thank you.